Well, hello, everybody. I'm Professor Sarah Singer, and it's my great pleasure to welcome you all to this launch event for the guide Litigating the Right to a Nationality. For those of you who've had the opportunity to already have a look at the guide, I'm sure you'll agree with me that it's a really fantastic piece of work. It's been developed by Dr. Bronwen Manby in collaboration with UNHCR and the Open Society Justice Initiative. And it's absolutely wonderful to have such an eminent panel of speakers with us here today to speak to this important work. Standing at nearly 100 pages of very rigorous research, but I would say also framed in an incredibly accessible way, the guide will undoubtedly serve as an invaluable resource for practitioners across the globe. And indeed, I think one of the amazing things about this practitioner guide is that it really is truly international in scope. And I hope that the impact will similarly be international. But there are others here who are far better placed to speak to the guide than I am. So please allow me to introduce our panelists today. We have here Dr. Bronwen Manby, who is a leading authority on nationality law and statelessness. She's also a lecturer in international human rights law here at the School of Advanced Study, University of London. Bronwen's research and writing focuses on statelessness, comparative nationality law, and legal identity. And she's worked closely with UNHCR on its global campaign to end statelessness and authoring a number of in-depth reports on statelessness in different regions of Africa, as well as on global policy issues, including, of course, the guide that we are launching this evening. For our other panelists, we also have at the far end, Adrian Berry, who is a barrister at Garden Court Chambers in London. He's co-author of the 4th edition of Fransman's British Nationality Law and has extensive experience in litigation to establish automatic acquisition of citizenship, to challenge refusals of naturalization, and to appeal against deprivation of citizenship. So thank you so much for joining us here today, Adrian, and sharing your reflections from what really is the front line of litigation on these issues. We also have Waikwa Wanyoike, who is Director of Strategic Litigation at the Open Society Justice Initiative, which is a legal action centre for the Open Society Foundations. He's a barrister and solicitor in Ontario, Canada, and an advocate of the High Court of Kenya, and is admitted by Gray's Inn as a barrister in England and Wales. He was the co-founder and served as inaugural executive director of the Katiba Institute, which promotes knowledge and understanding of Kenya's constitution and constitutionalism, including through public interest litigation. And I'm really looking forward to hearing your reflections today on the role that constitutions can play in litigating these types of issues. And last but by no means least, we have here Annie Larko, who is a senior statelessness officer at the Division for International Protection at UNHCR in Geneva. She works on statelessness law and policy issues and global advocacy on statelessness. And she supports UNHCR's regional bureau and country operations in their work on statelessness. She's also worked for UNHCR on refugee protection and statelessness matters in several countries in Eastern and Southern Africa and in the Nordic countries. So really a fantastic lineup of speakers, and I'm greatly looking forward to the discussions today. Following the panel discussions, there will be the opportunity for questions and contributions with the audience. So please do be bearing in mind any questions or contributions that you would like to pose to our panelists, or indeed be posing your questions in the online forum as we progress through the events. But without further ado, please join me in welcoming Bronwen to presenting the guide on litigating the right to the nationality. Thank you very much.
Thank you very much, Sarah, and thank you for chairing this event. And I am going to give a brief outline of what the guide is intending to do, before handing over to other panelists for their comments and contributions. So first, just to talk a bit about where does this guide come from. The origins of the guide are from a piece of work I was commissioned to do by the Open Society Justice Initiative, looking back over 15 years worth of litigation that they had supported around statelessness and the right to nationality and discrimination in identity documents and similar issues. There was an internal part of that for the organization itself, but also how can we make the lessons that the Justice Initiative had learned over 15 years available to other people as well. So the idea was that there should also be an outward-facing part of this work. UNHCR then picked up and also agreed to support the production of the guide, and in particular to host a workshop in Geneva earlier this year, which we back to back with the bigger forum which meant that civil society people were already in Geneva to discuss how litigation has worked in different countries around the world. But also the guide builds on the website that I maintain, Citizenship Rights in Africa Initiative, which has a database of a massive amount of work, including cases from around the African continent. And my own background is mainly in statelessness and nationality in Africa. But the Institute on Statelessness and Inclusion, Statelessness Hub, which has, it's relatively new, but building up information on statelessness is an important resource in this area. And the case law database established by the European Network on Statelessness, which I have a particular debt to because of the summaries of cases from different national jurisdictions, especially in Europe, in languages which I do not read, an important resource on litigation as well. So what were the objectives of the guide? To support the development of legal arguments in these cases. Statelessness remains a fairly niche subject for lawyers, and accessing what has been decided in other jurisdictions is not necessarily that easy to do if you haven't got the information at your fingertips. But also looking at the development of a litigation strategy and situating litigation within a range of work by other actors as well. Litigation can never be the only tool that you're using to try and impact the right to a nationality in society. The guide has a particular focus on what is termed strategic litigation. That is to say, litigation that is embarked upon with the particular aim of changing public policy or changing legislation or changing attitudes. But it's aimed at being useful for any litigation around the right to nationality, including litigation that's on part of an individual client to sort out their particular case, and that does not in itself have a broader policy objective. But also the objective of the guide is in some ways to demonstrate how far we've come in legal arguments around the right to nationality. In international law terms, one of the oldest international conventions is the Hague Convention of 1930, relating to certain questions on the conflict of nationality laws. And Article 1 of the Hague Convention starts off by saying it is for each state to determine under its own laws who are its nationals. And you see repeatedly stated, most of all, of course, by states, but also by textbooks, that this is the default position. It is for each state to determine under its laws who are its nationals. The second part of Article 1 says this law should be recognized by other states insofar as it is consistent with international conventions, international custom, and the principles of law generally recognized with regard to nationality. And these have changed enormously since 1930, and to a degree that could not possibly have been imagined by the drafters of the 1930 convention. But the details of the extent to which it's changed, I think, need more emphasis. So what does the guide do? It is a guide of two halves. The first half, roughly, in 6 chapters, looks at terminology. What is citizenship? What is nationality? They are synonyms. for the purposes of this report and in international law generally. Looking at litigation as an advocacy strategy set within other types of advocacy. Looking at developing a litigation strategy. At questions around constructing a case. So third-party interventions, expert witnesses, how you describe remedies, those types of issues. And some discussion as well about what do you do after a judgment, the types of follow-up that are necessary. And the second half, more or less, is devoted to legal arguments, starting off again with definitions, a major focus on the right of every child to acquire a nationality, which is perhaps the strongest obligation in international law, a focus on discrimination, on looking at arbitrary denial and deprivation of nationality, acquisition based on habitual residence, where international law remains rather weak in terms of providing obligations on states, but focus on statelessness in state succession, on birth registration, legal identity, and the connection to the right to nationality, and on consequential violations. For example, immigration, detention, lack of access to public health or education services, and so forth. I'm going to focus in particular in this presentation on three specific aspects dealt with in the guide. You'll be relieved I'm not going to summarize the entire 100 pages. So first of all, looking at the specific challenges of litigating nationality. How is litigation or strategic litigation on nationality different from other types of rights-focused litigation? And of course, there are many similarities. There are many ways in which this type of litigation is the same as other types of litigation. There are some specificities. Clients who are stateless or are unrecognized as nationals in the country where they are living and do not have a regular migration status and have no documented nationality anywhere else are especially vulnerable. And the complexities and risks for them personally in litigating are likely to be higher than some other clients. And sometimes the clients in right to nationality cases are also extremely unpopular. And I'm thinking in particular about national security cases where in deprivation, the client is unsympathetic to a general public, and that creates additional challenges in terms of litigating. Nationality can, of course, be politically very sensitive. Not always. The situation of abandoned children, for example, may not be that controversial, but sometimes where there are large stateless populations. And we should remember that most stateless people are stateless in the country where they were born and have always lived. Most statelessness is not in immigration cases, but around the largest populations of people are excluded for standard reasons of discrimination, and the decision to include them can be politically sensitive. And nationality can also be, in fact, not can also be, but is often legally very complex. The context of conflicts of laws, the question of lack of access or the impossibility of accessing consular assistance, even if you are only dealing with the laws of one country, it's not only the nationality you're looking at, but also the birth registration law, possibly the family law, questions of evidence and so forth. The legal issues can also be very complex. And historically, there's rather a lack of emphasis on statelessness as a problem, a lack of strong and supportive civil society networks. You may have women's groups looking at particular questions around discrimination in relation to sex and transmission of nationality, but not looking at the general issues. Child rights groups will tend to focus specifically on birth registration, but not engage so much with nationality. This is changing. We have the European Network on Statelessness, and we have the International Institute on Statelessness and Inclusion, and there are regional networks which are at a more nascent level in Asia Pacific, the Americas, and in Africa, but not a strong network historically. And so that also has made litigating nationality more complex. And a result of all of this means that the risks can be higher in litigating statelessness and nationality than in other types of litigation. Moving on to next issue, one of the strategic questions in litigating nationality is the question of framing. What actually is the problem that you are talking about? Are we talking about statelessness? Do you wish to describe your client as being stateless? There are advantages to this because of the particularly strong international and sometimes, although not always, national frameworks that exist around preventing and reducing statelessness. But sometimes to describe a client as stateless is to confirm a sense that somehow they are foreign, as opposed to people who should have the right to recognition of existing nationality of the country where they are living, or the right to acquire that nationality. Therefore, in some national contexts, it may make more sense to frame a case as being about discrimination, either based on sex, where the prohibition on discrimination based on sex, those frameworks are likely to be stronger, or on race, ethnicity, and religion. Or you could frame a case as being about due process, arbitrary deprivation in particular, and what have been the questions around removing recognition of nationality, or indeed of denying a person the recognition of nationality from the outset without any process to resolve what actually is that person's status. Questions of birth registration and legal identity can also be central and often procedurally useful aspect to focus on in litigation. And finally, one of the arguments that the guide makes is that the right to nationality as a positive right is increasingly possible to argue in litigation, both at national level and certainly relying on international law. And this should be the ambition of litigation in many cases. My final focus is just to point out the element of the guide that focuses on non-European jurisdictions. There is quite a lot written about nationality in European jurisdictions. We have the European Network on Statelessness and its database on nationality, which provides us with a lot of resource. But my own background being on the African jurisdiction, but also looking at inter-American courts, there's been a lot of contribution on nationality from both the inter-American regional human rights system and the African human rights system. Much more forceful than that comes from the European Court of Human Rights and the jurisdiction that there is from the Court of Justice of the European Union. There are a number of cases, the very famous Yinan Bosico case from the inter-American system, which was the first big case on this issue. Other cases on the expelled Dominicans and Haitians also relating to the Dominican Republic. And at the African level, from the African Commission, the African Court on Human and People's Rights, and the African Committee of Experts on the Rights and Welfare of the Child. There are a number of cases relating to Kenya, to Cote d'Ivoire, and politicians from different places who've had their nationality de-recognized once they became troublesome to a government in power. And in Africa, we have a new protocol to the African Charter on Human and People's Rights, adopted in February this year, which is quite groundbreaking in terms of the standards that it sets. And in particular, it's the first international instrument to establish the rule of double jus soli. A child born in the country of one parent also born in the country should be attributed nationality automatically at birth without any requirement to prove that they are otherwise stateless. There is also the protection for otherwise stateless children, but this provision in particular should eradicate statelessness within 2 generations. It doesn't solve all the problems, but it's a major contribution. There are also national decisions from the Bahamas, from Bangladesh, from Chile, from Colombia, from Kenya, from Malaysia, especially from South Africa, and from Uganda, which provide us with interesting precedents to look at in terms of the resolution of these cases. And this conversation amongst different jurisdictions has also enabled, I would say, or helped to enable the decision of the UN Human Rights Committee, the first very substantial decision at the UN level in the case of DZ versus the Netherlands from 2021, which established the obligation of the Netherlands to recognize the nationality of a stateless child born in the Netherlands. And there's while the main judgment refers, as is traditional for the Human Rights Committee, to the Human Rights Committee's own jurisprudence, the concurring opinion focusing especially on the cases from the inter-American and African system. And I hope that the guide will in particular provide people with resources about these other jurisdictions, which are perhaps not so well known. That's where I will wrap up. The guide is available online at the link on the screen. and there will be printed copies available. And if you emailed the link the hosts for this meeting, you can get advice on how you might perhaps be able to acquire a printed copy. We don't currently have them, but there will be that possibility. And thank you very much. I will stop sharing my screen and hand over to my co-panelists.
Well, thank you so much, Bronwen. I mean, something that just amazes me about this guide is the sheer scope that you've managed to encapsulate within it in a relatively kind of concise way, addressing these really complex and intersecting areas of domestic and international law. And I think, you know, some of those recent developments that you outlined in Africa and elsewhere are a real testament to the hard work that colleagues, that litigants and practitioners across the globe have put into this aim of eradicating statelessness and supporting people's access to the right to the nationality. So it's an incredible achievement, and I hope that this guide will, you know, go on to further support efforts in this field. Brilliant. I would like to turn to some of our other panelists now and ask each of you if you would like to share a reflection or a contribution from your perspective. And if I may, I will hand over to you, Adrian, to start us off.
Thank you. I'd like to congratulate Dr. Manby, first of all, on this excellent guide. And as a barrister in UK practice, I look at it and I think, well, who is this guide going to benefit? And the answer is me. It's going to help me enormously because I have to take these cases and I have to, we often respond to client problems on a piece-by-piece basis. And we don't think strategically. We think about solving a problem. We think about obtaining a legal remedy for someone. And if it's a person who's stateless or possibly stateless, that will be in the mix often amongst having an irregular migration status and having family members who may or may not share a nationality, even if the client doesn't. And so the first thing that I would do, having fully digested this, and I did have the privilege of an advanced copy, is to review the statute law on British nationality and the jurisprudence and on that statutory provision, and to think, what can we do to better provide for a right to a nationality in terms of our casework? So I'm very grateful indeed for the guide. It saved me an enormous amount of work, and for any practitioner who is confronted with working on cases and litigating, this is an absolute must. And its survey of the international as well as the regional scene in Europe is going to be of enormous assistance. Briefly, I'm going to deal with the way in which all the learning and the insight in this guide drops into the kind of problems that we confront in practice, because it's very important that firstly we understand the scenes in our national and local jurisdictions. And you know, if I was to pick good jurisdictions in which to look at how to litigate for the right to a nationality, I wouldn't start with the UK. So you can take my observations as working in a difficult context. There is no constitutional protection for citizenship in the UK, and there's no written constitution, so that's not a great start. And then following on from that, there's just ordinary statutory protection, limited human rights protection, and a judiciary unsympathetic to the idea that principles of international law should necessarily inform the cases that they have to decide. So it's not the best start, but that's why the guide's particularly useful for me in my practice and rethinking how to do things. In the context of my own jurisdiction, UK international treaty commitments are fairly limited because statelessness treaty commitment the availability of international treaties applicable is fairly limited. The UK has made some provision and has some reservations, but in litigating the rights which are provided for, say in the 61 Convention on the Reduction of Statelessness, it doesn't even necessarily follow that the standards advanced and advocated for by UNHCR and its statelessness guidance are followed. And a very obvious one is on the standard of proof, whether you have to, it's a reasonable chance or a reasonable degree of likelihood that you're stateless, which is the sort of approach taken for international protection in statelessness. And the UK's vision that actually it's a balance of probabilities, a higher civil standard which applies. All these sorts of problems occur in practice. And when we look at the guide, we look for ways in which we might overcome that. And there's a binding case law in the UK to that effect. So it's exceptionally useful for us. The problems which any system will confront include things like what happens if you're looking for a remedy and there's more than one class of nationality, which only may or may not give you a right of abode or a home in the world or a right of entry and residence into the country of your nationality. Seems perverse, but it happens quite a lot. And the UK, for example, has 6 classes of nationality, only one of which gives you automatically the UK right of abode, the right to live and work and come and go freely from the UK, as you find in Article 12 of the ICCPR. The other thing that I would consider is, of course, litigation is very useful, and lawyers and litigators, particularly like myself, we're very fond of it. But it may be that legislation or policy advocacy is also very important. And so the purpose of strategic litigation, as the guide sort of indicates and shows, is it works in partnership with other ways to ensure the right to a nationality. So it's particularly useful in that respect. The role of courts, of course, will vary according to the constitutional or legal structure of countries concerned. And so there isn't just case law in domestic courts. It takes place and works in different sorts of ways. And in the UK, legislation can trump case law. We have some hierarchy of laws, the sovereignty of Parliament, but in other jurisdictions, it will work differently. And it's always important when we're looking at national case law, national jurisprudence, to remember that, and contradistinction to international case law, it may be taking effect and have different sorts of meanings. It may have different status. Each judgment may have different statuses. And of course, the role of courts within domestic structures is connected to enforcement. Enforcement against the state can be a bit of a challenge. So you might get an interesting case, but is it going to lead to a practical difference? And the sort of things, when you're thinking about case law versus legislation, that sort of thing is very important. Is it going to be emblematic, or is it going to lead to a meaningful change, not just for the individual, but for a wider public interest, a wider class? One thing to think about, which I always think is very important as a national litigator, which is often missed, is that rules of evidence are incredibly important in national courts, and they make a huge difference to proving identity, nationality. I've already touched on burden and standard of proof. They vary enormously between common law and civil law systems for those that have inherited traditions that take those two approaches. And even within the common law system, the role between a written constitution, statute law, and case law jurisprudence, that can also vary in the constitution and written constitutions in some common law countries and not in others, and different layers of protection. Critically, in statelessness, where you're looking at a nationality that may be by descent from parents as opposed to the country of birth, foreign law is often a question of fact and needs to be proved. And that is absolutely vital. I've lost count of the number of advices I've written where we have a theory of the case, but we don't have the evidence to support it because expert evidence is hard to come by. So those are the basic challenges. In the European region, which of course the UK still forms a part, despite its best efforts to separate itself over the last few years, human rights is not particularly well tailored. Human rights protection is not particularly well tailored to protecting the right to a nationality. The question of using a right to respect for private life and family life as a proxy for the right to a nationality, and what we call Article 8 in the European Council of Europe Charter Convention is problematic, because you're always trying to come at it sort of 45 degrees off true north to try and say, well, this right to a nationality, it obviously involves the right to respect for private life. I know it's a balanced right, but it's still very important, and you need to think about it and protect it in this way. And a national court confronted by that may raise an eyebrow, going, well, we have to do no more than the Court of Human Rights does in Strasbourg, and the Court of Human Rights does relatively little through the MEC. It does useful things, but it doesn't protect the right at its core. And so that can be problematic as well. One final thing, just to mention briefly, which is but is also something that's always on the mind of a national litigator, is that states and courts and legislatures and governments, they have competing public policy interests. They're not massively interested in advancing the right to a nationality. You're going to have to persuade them. You have to persuade a judge, a legislator, a government minister. What are they interested in? They're interested in national security. They're interested in international relations. They're interested in tax and spend. If you want to persuade them You have to persuade them on the merits of the sort of normative case for why the right to a nationality is important. But you may also, and this is where being a litigator makes you something of a, well, if not a cynic, perhaps a skeptic, you may also have to persuade them of other things which you need, which this suits you because it addresses some of your other public policy agendas, or at least it doesn't cut across them or nullify them or suppress them. And so thinking strategically, whether it's in courts or in policy-driven advocacy for legislative change or policy change, often involves addressing those issues, even though you might think, well, what's wrong with you? Why are you so against the right to a nationality? It's very important to bear in mind that the people you're trying to persuade need persuading on their own agendas as much as on your agenda. So if you think about acquisition of nationality and good character tests, you think about deprivation of citizenship on grounds of fraud or conduct. You think about the exclusion of people and deprivation when people are outside the country of their nationality, as happens with people who are suspected of Islamist terrorism in the UK's practice of waiting till you've left the country before expatriating you. All of these things relate to domestic public policy agendas. And then one final thing just to think about in terms of the right to a nationality is that the increasing question is, well, states are often very concerned if in surrogacy arrangements, in other cases where children's parentage is in dispute, they want to allocate a parent to the child, and there may be nationality consequences of that. But they're not necessarily bothered about the nationality consequence if they can just allocate a parent. And so sometimes the question in a surrogacy arrangement, who is the mother, who is the father, who is the second female parent, if that's a relevant issue, for example, these things have nationality law consequences, but they're not necessarily the focus of nationality, and that a child can end up without a nationality and be stateless because the state thinks, well, job done, somebody has parental responsibility. But unfortunately, it's not one that necessarily attracts a nationality because the parent's own nationality and the law of that parent's nationality may not confer citizenship on the child. And so they're competing. The idea of anchoring a child within a parenting structure may not necessarily lead to a nationality solution. And that is a sort of emerging area on which we all have to think about. So the guide is going to be my reading over the Christmas vacation. It's going to be a project in the new year to think about how I can make best use of it domestically. I'm very grateful for Dr. Manby for her contribution. Thank you, and for her work on it.
Well, thank you so much, Adrian. I think you laid the groundwork so perfectly there, so comprehensively, setting out so many of the challenges and the different factors that a domestic litigator needs to take into account. And I think you set the stage perfectly for Waiko's contribution. So if we could hand over to you, Waiko, I hope you'll be reflecting even further on the role of litigation in different domestic contexts, different structures.
Thank you, Sarah. And just to start by congratulating again Dr. Manby. And I know the amount of work that has gone into this. I saw her working with colleagues and just the amount of intellectual input and research that you did on this. It's amazing. And obviously that's reflected in the guide. I wanted to do two things. I wanted just to talk about strategic litigation generally, partly because that's what I do on a daily basis. That's what Open Society does on a daily basis. And then I was going to address more specifically Sarah's question on domestic litigation, but specifically looking at opportunities in what we call new constitutional democracies in terms of litigating the right to nationality. But I just wanted to start with possibly 3 human stories based on very personal interaction relating to statelessness. Most of the people here and most of the people hearing this would have nationality. And when you have nationality, you really cannot comprehend unless you interact firsthand with somebody who does not have nationality, what rights to nationality and having nationality means. First, a gentleman called Adam Hussein Adam, and Adam unfortunately passed away in 2016. And the Nubian case, and you'll find quite a bit of that in the guide. the work, a lot of the advocacy work around the Nubian case was curated by Adam, who was a Nubian himself. But Adam managed to find ways to go to school in Kenya, primary school and secondary school. But when he finished his high school, he won scholarship to go and study abroad for his degree. He was never able to leave the country and to go take up his university studies, just because he did not have citizenship. He could not access a passport at the time. And I often try to imagine what his life would have been. For example, if he had citizenship and he had pursued further studies abroad. The second is of a gentleman I represented when I worked in Toronto, who was stateless, from Western African descent, but nobody could be able to place him, because that's how statelessness works, to a specific country. And I remember shuttling with him between the Gambian and the Senegalese embassies, because the government, the Canadian government, was pushing for those embassies to recognize him as their national. And for me, that gentleman, I won't put his name out, what really affected me, or what shocked me, is the level of being stranded that one becomes when they're stateless. The third relates to my home country in Kenya. A young man of about 34 now. I met him because I needed some work done, a carpenter, and I noticed him. He was very, very good at what he did. And we started talking on the phone. He came and did some really good work for me. And then I would send him messages on the phone, and he would take a long time to respond to those messages. And it never occurred to me, even though he was so good at his trade, that the reason it took him so long to come back to me whenever I would send him messages is because he couldn't read. And he couldn't read because he was stateless in Kenya. And so he never managed to register for even elementary school when Kenyan government insisted on even a birth certificate or document of nationality. These are the real stories, and these are not necessarily the worst of cases, but these are the real stories about being stranded when it comes to statelessness. I wanted to go back to the very basic, and Dr. Manby has started on this. Adrian has also started discussing, and just talk about, when we talk about strategic litigation, what are some of the things that then we need to think about, and especially how do we relate that to litigating the right to nationality? And I just wanted to explain three things. The first thing is, what do we mean when we talk about strategic litigation? What is it? Why not just litigation? The second is, what are those factors that define or help us define strategic litigation? And then how do we go about putting those factors in place as the third point? So strategic litigation. A lot of us who will read literature on strategic litigation, you'll find that the term is used interchangeably with other terminologies. So, for example, social impact litigation, public interest litigation, all movement lawyering, or anything. There are quite a number of those. But the term strategic litigation for me is critical, and I'll explain why in a minute. But the more important point I would want to make about strategic litigation as a concept, as an intellectual concept, is that strategic litigation is value neutral. Value neutral in the sense that it's about how you go about doing litigation. So there are a lot, for example, of corporations which are undertaking what we call SLAP suits, strategic litigation against public participation, for example. And they call that strategic litigation. So it's how you do the litigation that matters, and I'll come to that in a minute. That is contrasted with public interest litigation, because public interest litigation assumes that you're doing this for public interest. And there is an inherent assumption that the public interest is for the good. And so in that sense, then value public interest litigation as opposed to strategic litigation acquires value. But why we often insist on strategic litigation is because strategic litigation, as explained by Dr. Manby, is one tool that can be used alongside other tools and in combination to be able to deal with significant or complex social or legal issues. And that now takes me to the second point in terms of the factors that are to be considered when you're thinking what is and what is not strategic litigation. And just two things to talk about here. One, the first thing we think about when we think about strategic litigation is impact. What will be the impact of this litigation? And often a lot of litigation that we will see as lawyers is what we call reactive litigation. Somebody has done something, you're going to defend. The government has done something, you are thinking about how do you get this person out of trouble, and things like that. So you are reacting to a situation. Strategic litigation, on the other hand, almost always is what we call proactive. So you're the one who is actually converting an issue, a problem, a social problem, a legal problem, into a legal and litigable issue. And so the first thing then to think about is impact. And there are different types of impact. The first one you can think about is what we refer generally as material impact. And material impact is just the general kind of impact we often see from litigation. So somebody has sued because they were tortured, or because they didn't have nationality, and the court has declared that they should get nationality. So there is a very specific outcome related to that litigation. The second kind of impact is what we call instrumental impact. And often instrumental impact tends to go beyond the individual litigant, so that it affects change in a broader sense. So when you think about it, and you think about, for example, when people challenge a law, or as part of litigation, you challenge a law for being illegal, unconstitutional, or however you want to define it, and the court agrees with you, that is kind of instrumental impact. The reach will be significant, not just to that individual, but to others. Then finally, there is what we call the non-material impact. Think about right to nationality again. It's easy to go to court. It's easy sometimes to get the court to declare a person that they should be accorded nationality. But we live in societies which sometimes tend to be very xenophobic, tend to be very unaccommodating of what we would refer to as foreigners. Does litigation have a role in terms of changing social attitudes when it's an issue that may be resolved through law? And sometimes recurring litigation or planning litigation in a certain way does tend to do that. And we've seen it, not just in nationality context, but for example, sexual orientation, the kind of litigation that is done, helping societies change social attitude. So that's non-material. Second, the tactics. You can't do strategic litigation. In fact, strategic litigation is more about tactics and what is more of a defining feature. And again, that has been alluded to somewhat. And what do we mean by tactics? Tactics is how you plan the litigation and the things you do to make sure that your litigation is impactful. Ordinarily, a lawyer getting a case, all they look at is rules of evidence. They decide what kind of remedy they will be seeking, and they look at the easiest path to get there. For strategic litigation, on the other hand, and especially strategic litigation for complex issues like right to nationality for communities, you don't look for the quickest and the easiest path. You think about how do you sketch a path that actually gives you the type of impact, that the different categories of impact we've talked about. And in doing so, then you have to deploy tactics, some of which were alluded to earlier. Where do you go? Do you go to a national court when you have the choice, or do you go to a regional court, or do you go to an international court, right? That's part of the tactical consideration. Within the national court, if you have the option to bring a case in Manchester as opposed to London, do you go to Manchester or do you go to London? And why are you going to Manchester as opposed to going to London? Again, a tactical consideration. Expert evidence that Adrian was talking about earlier. When do you deploy expert evidence? And for what? Maybe not specifically to speak to this particular client, but to speak to the issue in general. So when you think about strategic litigation again, and on complex issues, because issues of nationality, we're talking about not just individuals, we're talking about communities, are very complex. Let me conclude with just the constitutional, the place of constitutions, new constitutions, and only say three things. One good thing about new democratic constitutions, unlike places like UK, is that they have offered tools that are much easier to use in litigating some of these issues. The first is what we call standing. In most old constitutions, it's very hard unless you're affected by an issue to go to court and present a case. In new constitutions, groups that are not affected, individuals who are not affected, sometimes are able to litigate for people who are affected. And people who have problems with nationality may not be able to litigate always. Second is that in new constitutions, it's easy to bring up issues of international law, even in domestic courts. And again, that does help advance the right. And that, what we've seen with new constitutions is recognition. For example, very specific recognition in the constitution of issues to do with statelessness, and especially for children. And again, Dr. Manby referred to that. Let me stop at that.
Thank you so much, Waiko. A really comprehensive examination. But we will we'll move on now to Anne. Do you want to share some reflections? I think giving us stepping back a little bit from the frontline practitioner and giving us a bit of a global perspective on this issue in your role at UNHCR.
Thank you, Sarah, and I'm very pleased to be here this evening with all of you. So indeed, I will say a few words on the global picture of statelessness before saying a few words about the guide as well. So as most of you would know, UNHCR, besides having the refugee mandate, UNHCR is also the mandated UN agency to work on statelessness, and that mandate extends to identification of stateless persons, protection of stateless persons, and prevention and reduction of statelessness. And the two UN statelessness conventions, the 54 Convention and the 61 Convention that have also been mentioned already, are the cornerstones of the international law on statelessness. And one of the key objectives and focus for UNHCR is accessions to these conventions and the implementation of these conventions. And as you've already heard, statelessness remains a significant global problem. Currently, UNHCR, in its annual statistics that we compile, reports 4.4 million stateless persons and persons of undetermined nationality. But this is recognized and agreed that it's quite an underestimate. And this is because Only about half of the countries in the world report any figures on statelessness. And those that don't report any include countries with known and sometimes large stateless populations. And even those countries that report figures on statelessness, often these figures are only partial figures, or estimates are sometimes quite outdated as well. Also, as already mentioned, the discrimination is really at the root of statelessness in many, many instances, and ethnic, racial, religious discrimination. And the majority of stateless people belong to minority groups. And then there's also the gender discrimination. And still today, there are 24 countries in the world that discriminate women. So women don't have equal rights with men to transmit their nationality to their children. So if the fathers cannot or are unwilling to confer or are not present to confer nationality to their children, these children are rendered stateless, especially if there are no safeguards in place for otherwise stateless children, which is the case in most of these countries that have such discrimination. And then there's even a larger number of countries that otherwise limit women's nationality rights that can also lead to statelessness. And other speakers have highlighted, and Waikwa also, in terms of like the rights that people cannot access that don't have nationality. So nationality really is often the gateway to other rights. And if people don't have that, in many contexts, they cannot access education, healthcare, or formal employment, and often are really marginalized in any society. And they are not able to even register their births or other life events, get formally married or anything like that. So the impact really is quite severe. And when you listen to the stories of stateless people, as Waikwa has referred to as well, it's really a terrible injustice. It's very clear what lack of nationality blocks you from doing. So in the past decade, UNHCR wanted to really accelerate progress to solve statelessness. And this was done through the IBELONG campaign to end statelessness, which is now drawing to close. It's been 10 years, and unfortunately, we didn't end statelessness in these 10 years. It was a very ambitious goal, and some good progress has happened. There's been definitely the awareness around statelessness has increased a lot that this campaign has been driving, but of course there have been a lot of good regional initiatives that have helped with that. Many countries have reformed their nationality laws in order to better protect stateless people and to prevent statelessness. And also countries have taken steps to resolve statelessness issues for individuals and groups. So over 500,000 stateless people have acquired nationality in the past decade. And these are the ones that have been recorded and we are able to report on. There are more cases than those, but those that come up in the official statistics. And countries included, for example, Turkmenistan and Kyrgyzstan in Central Asia have resolved all known cases of statelessness. And other countries have granted nationality to thousands, for example, Kenya and Thailand as well, and many others. So good progress has happened, but it hasn't been resolved. And there is recognition that the change that is happening, it's just not happening fast enough for all those people who are still stateless. And kind of to build on the progress made under the IBELONG campaign, but also recognizing that statelessness really requires a whole of society approach. UNHCR has, with others, launched an initiative called the Global Alliance to End Statelessness that is really designed as a much more of a multi-stakeholder approach, bringing together governments, stateless organizations, other civil society, academia, UN agencies, and others. And this alliance was launched during a high-level segment on statelessness in Geneva in October. And currently, this alliance, which is very recently launched, has 115 members, or somewhere there, over 150 members. That includes 70 civil society organizations, 10 intergovernmental organizations, and 22 governments. So these numbers are increasing. So this has been very exciting to see that it's taken off quite nicely. But of course, a lot of work remains to be done to increase the membership. And also then, of course, so that concrete action can be taken. In this global alliance, importantly, there's a role for the stateless communities that are quite in the center of this, and UNHCR engaged quite extensively with stateless organizations in the development of the alliance. And as of now, there are 14 stateless organizations as members of the alliance, and 3 of them also serve as members of the Global Alliance Advisory Committee. And this committee ensures that the lived experiences of stateless people shape the priorities and the initiatives of the alliance. So would definitely encourage everyone to look into the Global Alliance. There's a website and your organizations to look into the membership of this alliance. And then I'll just turn to say a few words about this guide. I think a lot has already been said, and at UNHCR we're very, very, very grateful for this collaboration with Bronwen and Open Society Justice Initiative, and all the contributions that we got, in particular through the roundtable that was organized, that brought together around 30 experts on statelessness and/or litigation, and that really shaped this guide. And for UNHCR, it's an important tool as we recognize the power of litigation to influence change and systemic change, and especially when it's strategic litigation. And we know that litigation and state litigation has so far been an underutilized tool to address the right to nationality. And we hope that through this guide, we can increase this and we can bring in more litigators to take up cases on statelessness and the right to nationality. And maybe just to highlight one element of the guide, Bronwen spoke about many, and so did the other speakers, and maybe just echoing a little bit on what Waiko was also saying on the broader advocacy and the strategic elements of the litigation, and importantly, the coalition building and the allies that are required in order for the litigation to potentially lead to something that is bigger than just for that one case. And in that, again, just centering the experiences and the views and the opinions and how the people with the experience of statelessness see it and how they want that litigation to be shaped. And but also others, of course, parliamentarians, politicians, and importantly, media, that we need to work with to prepare the public as well in these cases that, as the litigators would know, often can take years and extend to beyond the judgment, whether the case is won or lost, and how to deal with that. And where also it's important that the affected people are part of that preparation for what happens after the case is when there's a decision. So this launch is the second launch of this guide. We had another one in Bangkok a couple of weeks ago, and we aim to continue to roll out and raise awareness around this guide, and really in any platforms and events. And if you have any ideas and would like us to support, if you want to speak about this guide in events that you may have, we are very happy to come in and support on that. And in litigating right to nationality, but also always more broadly, happy to support.
Oh, thank you so much, Anna. I think you set out the global sphere so perfectly there, and you know, some of those statistics were quite astounding in laying out the extent of the challenges that nationality that statelessness poses across the globe, but also the great developments and strides that have been made in addressing that. So thank you so much. We have a few minutes now for questions and discussion. So if you're in the audience in person or indeed online, please feel free to raise your in-person hand if you'd like to pose a question or comment, or pose a question in the online chat space. I might abuse my position as chair and start us off if that's okay. I have a question. I think it's for Bronwen, but I'd be interested for others' perspectives on this as well. So we've been speaking a lot about the role of litigators and practitioners, but something that keeps cropping up to me is it seems to me that statelessness seems to be quite an intractable problem, but it's quite a political problem. So to what extent do we need political solutions to this issue? And this might relate to, you know, some of the comments that Adrian made about, you know, needing to needing to engage, government policymakers and frame things in a way that was politically acceptable, or indeed what Anna was just talking about adopting a whole of society approach and really laying the groundwork for legal change. So Bronwen, I'd really welcome your thoughts on this, but equally, if other speakers would like to jump in as well, I'd be really keen to hear your perspectives.
I think statelessness is a political and a legal problem, and a social problem. But it is, it's unique. It's unlike other types of human rights in that, the right to healthcare or the right to free speech or many other rights, they have a meaning in themselves without any law. And nationality only has a meaning in the context of law. And so legal solutions are absolutely necessary, and litigation can make a contribution to that. But in the end, litigation in the context of a very poor legal framework can't achieve so much, except perhaps making evident the problems with the legal framework. So in those countries where statelessness is the most intractable, Myanmar, litigation is not going to solve the situation of the stateless Rohingya. However, if one thinks about a country like Kenya, which has had known populations of thousands of stateless people, and there still are, but the litigation and indeed the new constitution in Kenya, which enabled more litigation at national level, the regional litigation around the situation of the Kenyan Nubians, it was not the situation that the African Commission on Human and People's Rights and the African Committee of Experts on the Rights and Welfare of the Child issued decisions, and the Kenyan government said, oh, yes, of course, we'll do that. But the litigation created a focal point for other advocacy and a focal point for what were the remedies that were talked about and how does one think about that. So litigation in these contexts can make that contribution, but it may be a solution for an individual client who has a particular problem to solve. Litigation may be the solution for that client. But in terms of changing broader patterns of injustice, it can only ever take place in a broader context of other types of advocacy.
Thank you. Adrian, would you like to comment on this? I saw you scribbling away there as soon as
I'm just making a note of the question. I think from the perspective of litigating within this jurisdiction, it's different to what's happening in Myanmar, because it's absolutely right that these sort of group issues of group discrimination are to be politically solved. In the UK context, you have a manufacturing of statelessness if you deprive people of citizenship when they're out of country, in Syria or in Turkey or in other countries on an individual basis. And of course, that potentially gives rise to a right of appeal on deprivation of citizenship. And it goes to a national security court where there is evidence heard in secret as well as open evidence. And as you might imagine, all the good and useful stuff is in secret, and you never get to see it. So the political solution is also relevant there, but it's about persuading politicians in a very difficult sell that it's better to use your own criminal law against your own citizens if you think it's applicable, rather than simply doing the sort of Pontius Pilate maneuver and washing your hands of them when they happen to leave the jurisdiction. So that is a political question, and it is possibly a question of advocacy. I've been involved in deprivation of citizenship appeals where people are expatriated overseas, deprived of citizenship, and they're not happy cases. They're not really going to win one, because national security can be a trump card, and almost invariably is on decided case law. So it's true, you could illustrate through litigation, look how hopeless the situation is, and that has a strategic value. But outside of political initiative, to try and persuade people of these competing public policy objectives of securing the realm, if you like, that's all what national security is about, that can be achieved by not depriving people, not manufacturing statelessness, but by using the criminal law, which obviously has extraterritorial reach for certain criminal offences over your own citizens. So I think that's so they can work together, but you have to be smart as to how you bring the cases and what you're seeking to show.
Thank you so much, Adrian. Waikwa or Anne, would you like to come in on this question? There's no obligation.
I was just going to say, actually, the implementation. Even when you do the case, the implementation is very, very political. And so that's partly why I think Bronwen did dedicate some pages to that. partly because governments will even get decisions and refuse to implement. And so you have to have a political strategy. What, in addition to litigation making the issues a focal point, they do actually give the moral validity. When you have a decision of a court, it does give moral validity to a political campaign. And so it's one additional tool that you get. And finally, again, and this is why I like constitutions in new democracies. Most of the new constitution says things like political question doctrine doesn't apply. And so you're able to litigate issues that are very, very political. And judges, and especially bold judges, actually able to offer remedies that go into what you would traditionally consider political.
Thank you. I think we can bring you as an advisor to try and get a constitution here in the UK to assist our legal advocacy. We have some questions on the floor, so I'll say one and then two. If you,
that
I think
work.
it doesn't work. So if you could say your question, and then I might just repeat it back for the benefit of the.
Yeah, Chris Nash from the European Network on Statelessness. Those not familiar, we're at the Society Alliance, with 180 members in 41 European countries. Firstly, to say congratulations to Bronwen and all involved for the toolkit, an excellent new resource. And I was in touch with Bronwen colleagues when she was authoring it, because coincidentally at the same time we were developing our own litigation toolkit in Europe, and took a bit more focus on the migratory aspect of statelessness, but these tools are critically important. Bronwen was also kind enough to mention our statelessness case law database, which includes over 300 summaries of